And so we'll go ahead and get started. I just wanted to share how much we're grateful for this opportunity to have a conversation with you. And, I've been with Deaf Hope since 2005 and been hearing a lot about the important work that you've been doing to address inequities in the courtroom, particularly when you have a person in the courtroom who is deaf, deafblind, hard of hearing, whether they're a survivor, a victim, as the system refers to them, or a person who causes harm. I know that equity and inequity is an important consideration, not just for that individual having access to courtrooms and the language of courtrooms, but also how the legal system at large works and what's expected for their cases. I know that often we, as advocates in the field, see a lot of misunderstandings. We see lack of access in the courtroom, and we see that too often. It's something that most judges that I know of might be aware of generally, but then they don't necessarily go beyond their typical duties or scope. And you have spent the hours, the years of work that it takes to really figure out how to best improve and uplift access for your courtroom. So I first wanted to start off by saying thank you.
Oh, well, thank you. I appreciate that. It's been a lot of work. I didn't realize how much I had to learn and till I started working on it. But I really have enjoyed this learning so much about deaf culture. And the byword in my courtroom is procedural justice, because if people don't feel like they're being listened to and that they don't have the access, then no matter what the outcome is, they're not going to feel good about that. And they're going to be, for offenders, they're not going to comply with court orders. But if everyone feels that they're being heard and their full rights are being respected, I find we have much better outcomes. So.
Yes, exactly. That is a situation where every person deserves that procedural justice, and it's new terminology for me actually. And I'm thinking about many more questions that I have for you about it. But first, I really, for the audience joining us today, I wanted to introduce myself. I am Brian with Deaf Hope, and I'm from the Deaf Action Team. We provide technical assistance to the deaf domestic and sexual violence field, and we have here today with us Judge Wendy Millian. And I want to just share a little bit about Judge Millian for our audience so that folks can better understand why you're here. And during this event next week, we're going to be having a learning engagement on the topic of legal advocacy. And this topic is one that many deaf domestic and sexual violence advocates want to learn more about. And I'm not just talking about people who are new to the field, who are just kind of jumping into this work. I think, people who are currently taking the domestic violence and sexual violence 40-hour advocate training that we have, this includes them, but it also is for folks who worked in the field for many years. We're seeing a need from all advocates of all experience levels to get more knowledge and experience on how to navigate court systems, whether that's criminal justice or family law. Those are two big areas that we see a large area of need and motivation to learn more about and to develop skills so that we're better able to effectively serve deaf survivors. And so I just want to, show appreciation for having you being here with us today. And you are from Tucson, Arizona, in a courtroom. I'm just wondering if you can tell us just a little bit about your court experience and general work.
Yeah, for the last 13 years, I have run a domestic violence courtroom. So we're dedicated to cases with intimate partner relationships. And we take the most serious cases. They're misdemeanors, but a lot of them end up being much more serious than misdemeanors for various reasons. And one of the things I noticed was the court is in general had split up interpreters. So like one of the courts took any case with a Russian interpreter. I had volunteered to take any case with ASL interpreters just for resource management. And I recognized that no victims ever showed up, no deaf victims ever appeared in my courtroom. And it made me start thinking about what kind of barriers are they facing in addition to just being domestic violence survivors, which they have, you know, a whole set of barriers by themselves. And so that got me start reaching out to the deaf organization in our community and getting them connected with our victim services agency. And then we found Amber, which was wonderful here at Deaf Hope. And so it was a real learning experience for all of us, but it was in the context of I have a domestic violence court where there's advocates in my courtroom every day. And part of, you know, the success story of my court is the fact that we have that outreach to victims and that they're always front and center in anything we do.
Well, thank you for sharing that. That really helps us to know more about your work. And, you know, by what you just shared, how we see that you're a leading example for other judges in doing this equity work, and how a courtroom can look for deaf survivors and people who have caused harm. You know, I think one lens or one way that we think about, you know, why should they get special treatment? You know, people sometimes argue or object to special considerations. And what we know in our work is that within the context of the courtroom, the playing field is not level, and that deaf, deafblind, hard of hearing survivors and people who cause harm that are court involved experience huge, significant inequities for the reasons that you mentioned, the barriers to systems, and language access is not always there. And you see that there is a huge mismatch between court culture, what we kind of advocates call the culture of the courtroom, versus community experiences and cultural values. And for example, our community way of telling a story is one example. We typically will start from a place that's way back in the past, share all the people that are involved, give a level of detail that sometimes can feel off the point. And that's not often the kind of answer that is expected, you know, from the judge and attorneys in the courtroom, that you're giving way too much detail, you're going way too far in the past. And so that's one example of a cultural mismatch or a cultural you know, disparity, where we as advocates then feel a responsibility to better prepare the survivors in the best ways we can for domestic and sexual violence cases, whether it's protection order hearings. Based on our experience, we try to share what we know and what we can expect for their case. And we hope to help them be better prepared, whether it's through training, you know, about information role playing. Let's ask you a question. What would your answer be? And have the deaf survivor get an opportunity to tap into something that is very traumatic and triggering and painful, and allow them an opportunity to when they tap into that, be able to frame it in a way that their answer matches the expectation of the courtroom. We see a huge benefit in that kind of preparation and work. And so my question really to you with that context, I'm wanted to ask you from a perspective of deaf advocates, what do we need to know about court proceedings, about courtroom processes, about court culture that can better prepare advocates for working with survivors in courtroom settings?
That so depends on, you know, the judge and the courtroom. So I guess I'd step back a little and say, if there's anything that your agencies can do to reach out to the courts that you're dealing with and do some education, that would be huge. Because let me just say that when I started working with the deaf community, I thought everybody understood American Sign Language. I thought everybody understood English. I, you know, I didn't know anything about deaf culture at all. And so having our local organization come in and train me, the other judges, and all of our attorneys and court staff was hugely helpful. And so I guess I'd say if you're in a situation where there is a lawyer involved, like a prosecutor, reach out to them as an advocate and explain some of the things that they may not understand about deaf culture. I just really specifically remember that early on, we would have offenders who would say, oh, well, that's just how we get people's attention in the deaf world. We bang cupboards. And then I realized, yeah, but you like tap someone on the shoulder, or you do one thing. You don't like intimidate a survivor by, causing all of this noise and disruption. And if you didn't understand that, you might just say, well, this is like a fight, right? And this is like just someone. And so understanding the different ways that can be used to abuse someone who's deaf or hard of hearing is really important for the judges. I think it's really good that you are preparing the survivors to appear in the courtroom, because it's true, we have a lot of cases. And so when we do protective order hearings, we tend to be like, okay, wait, we need you to get to the relevant facts. We can't hear all this backstory because we've got 3 more cases to hear. So I think that is important, that you talk to your survivors about, you need to, really pay attention to the specific question and answer that specific question. I'm trying to think of the things that, I guess the culture, and you all know this, the culture in a courtroom will always be to listen to the person that you can talk to in your own language first, right? And so it's really important to make sure that that judge sees you and the survivor there, especially if the offender is English speaking, is not deaf. So I don't think it hurts to, and it's going to depend on the judge. It doesn't hurt to ask the judge, can I speak to you for a minute and explain, how we communicate? Or, for example, we've ended up putting our ASL interpreter right at the front of the courtroom in front of me, so that everybody can see the interpreter, things like that. So talking to the interpreter even and saying, okay, this is what's going to help the victim. For example, we used to have a practice in my courtroom where everyone would just come up to the bench, and we realized that even the people who could hear, the victims would be in the back of the courtroom. They couldn't hear anything we were doing. So now I place everyone at the tables, and I make sure the interpreter's up front so that everyone has access to what's going on in that courtroom. I feel like I've gotten kind of astray, so I'll have you ask me the next question and see what other specific things you want me to talk about.
Oh, no, you're doing great. And actually everything you shared is so rich. We're tapping into the wisdom and I'm soaking it up. It's all very useful because you're also demystifying some of the courtroom processes and how judges think and how this process goes. I think so many of us have a first concept through Hollywood or television media that, many of our community members carry those myths or inaccuracies around what things should look like. And I was thinking of an example of that where, we're not used to the concept of lawyers maybe going and having a session like in chambers conversation. And this concept might somewhat conflict with our expectation of, no, it should all be transparent. We should be there. I should be there. And the deaf community cultural value is around inclusion and transparency. And we're involved in those conversations. And so seeing the kind of lawyer huddle or a private conversation with the judge can feel like we don't know what's happening and our decisions being made without me. And it brings up a lot of uncomfortable feelings that might be rooted in childhood trauma around access in the home. And I can't speak for all deaf people having the same experience, but I think often there is a sense of what's going on over there and why am I not a part of it? Why am I not informed? And so, I'm trying to land my point here. That your comments brought up a lot, and I really appreciate them because you're sharing information about how we can dispel some of our misunderstandings about courtroom procedures and what happens. I love your suggestion of reaching out to, for example, prosecutors and offering education, training, support. I'm wondering about, from a prosecutor's perspective, especially, but how can we, do that? We think about reaching out, can we reach out directly to judges for a deaf cultural discussion?
I think it depends on the judge, but I definitely think you could do that. You could also reach out to the court administration because they're always looking for opportunities to educate their staff. And I will tell you that to me, it's just as important to have staff and police and everyone educated in deaf culture because the bottom line is if that victim is not treated well from the very beginning, why would she ever come to court? And so I often, oops, sorry, I have my phone on. Why would she, if she's not respected by the police officers and just dismissed because she doesn't, they can't understand what she's saying, why would she come to court? Why would she think it would be any different? And the same thing with if she shows up at the courthouse and security is like, well, we're going to write to you. And if you don't understand what we're saying, then we, can't process you. So to me, it's super important to offer that kind of training to the whole system. One of the best things I think we did was have a courts, cops, and coffee meeting at Community Outreach Program for the Deaf. And we figured if we brought the cops, everybody would come because everyone wants to complain to the cops, right, about how they got a speeding ticket or whatever. And then we also had I had my lawyers, my public defenders, my prosecutors, but I also had our victim advocates and I had our court staff there to talk about procedures and how to get protective orders. And it was just great. But what I really liked was that our police department sent some of their internal affairs officers to talk to the deaf community and ask them, what are your issues with us? Like, how can we, work with your community better? So, it never hurts to ask these organizations. And like I said, it was super enlightening for all of us when we had these presentations. So things like that, like people, I always have these experiences where deaf people come to court and we are writing them things, right? Because we have a hard time getting interpreters sometimes. And now I've learned I have to say, can you, do you speak English? Can you read what I'm writing? Because we have such a wide variety of what people can understand and what we just assume they're going to understand. We're like, oh, they're deaf, we'll just write something. Well, that doesn't always work, we've learned. And we've learned about CDI interpreters and so, but if you're only dealing with them every now and then, they're just like, oh my gosh, this is going to slow me down, this is a hindrance. And so the more we understand the deaf culture as members of the justice system, the easier it is. And I'm not saying that's right. We should, treat everyone with respect and try and give access. But at the end of the day, everybody's trying to go as fast as they can in these systems. We have so many cases.
Well, I appreciate you sharing that. I love that you're showing us advocates what is possible, that it is possible to have a listening session with members of the court personnel and staff, law enforcement, if it makes sense to bring the deaf community into that. I love those ideas that you shared. One thing that I noticed myself and in my advocacy experience in court, as you said, each judge responds in different ways. They have their own approaches. And I've noticed that some judges are more willing to, quote unquote, allow an advocate to speak up in a courtroom. And there are other cases, other judges, that there's not the same response, that it can feel somewhat, shut down, that, there's no space for the advocate to share a word at all. And I'm wondering if you might have some tips, suggestions on how, if advocates are finding themselves in a hearing in space where, for example, they haven't been sworn in, if the advocate is noticing that the survivor is really struggling with answering the judge's questions or the attorney's questions, that there's struggles happening, and those could be because of language access. It could be just because of trauma, their traumatic experience, that they're just not able to respond, they're shut down, they're crying, they're flat, they have a flat effect. So specifically, maybe questions aren't coming through to the interpreters exactly clearly in those situations, that they're not able to capture the aim of the question or the response. You get sort of this word salad sometimes because of those barriers, and the aim is not particularly clear. But as an advocate, we know the survivor, we know the process. We can often provide some contextual information, whether that's specific to the survivor or to the process, that could make it more smooth. And as I was saying, sometimes it just feels like we're expected to stay silent. There's no space for us to participate. And so I'm wondering if you have any strategies for how advocates can handle situations like that. What could we do when things aren't clear? How do we kind of chime in or interrupt, even when the judge has maybe said, you can't do that? Only
Yeah, I
speak.
think that's a hard one because, advocates have really not got a place in the context of those hearings. In Arizona, we have a rule that I helped implement that we can have advocates sit at the table now, but they still can't say anything. I don't think it would hurt to at least say, Judge, could we take a 5-minute recess to let the victim just, reset, have a drink of water. I can see that she's not understanding all the questions. I can't tell you that every judge will allow that. I mean, some judges are very strict. And, part of it's like, okay, this person has an advocate and this person, the other side, may be by themselves, right? So we're trying really hard to keep that neutral stance there. But I do think that might be the easiest way in a court where you haven't been allowed to say anything, is just to stand up and say, Judge, can the victim just take, or the petitioner just take 5 minutes just to reset, and then maybe talk to her, maybe get an aside with the interpreter and say, this is what we're seeing here. She's not understanding the way you're doing this. But I think that's a tough one. I think it's really hard when the judge is saying, no, you have nothing, but you're there as, for moral support, basically. And that's why I think that training is so important, because then judges might understand and say, is there something she's not understanding? Is there something that you can help the court do that would make her, feel more comfortable in the situation? But aside from that, you've got judges who are just going to dig their heels in. I mean, it's easy for me to say I would ask those kind of questions because I've been doing it for so long, and I have, advocates in my courtroom that understand that they can raise their hand and say, hey, judge, the victim's here. She wants to say something, and I will do that. But I think that and I think if you do pose it, and I can talk to you about that more, as a procedural justice issue, judges recognize that. And so if you term it in those legal terms like language access and procedural justice, then even the judges who aren't, very open to like changing the way their courtroom runs might be open to that, to understanding that this is about justice. This isn't about just someone who's traumatized, and they may not want to hear about that, but they do want to make sure that they're, in their mind, enforcing the laws correctly.
Oh, that is a wonderful tip. Thank you for sharing that, because this is the first time I'm hearing that phrase, procedural justice, that terminology. And so I'm mentally taking notes for myself about using that, because it does come up. It comes up in hearings as I get called to support survivors in DV court or restraining order hearings. It's just a frequent ask from the field, from Deaf Hope, from other organizations, to provide that support. We're being called to do that for survivors in DV courtrooms pretty frequently, and that is something that will be helpful. I know that we don't have a lot of time in this conversation, and I could talk to you all day. I wish I could. I want to respect your time. You have covered some significant aspects of, possibilities that advocates can consider when providing support to survivors, but also you've mentioned what we can do to provide education. That educational piece is really important to the judicial staff and attorneys and all the personnel. I was wondering if you could share just a little bit more in our remaining time about how deaf advocates can particularly advocate for survivors who have complex identities. They might be from a specific racial ethnic group. They might have recently moved from another country. They might have a unique language need, intellectual disability, growing up language deprived, and not having access to language in a formal educational setting. There's all these complex identities that can come up frequently in cases. Based on your experience, what are some strategies or recommendations that you'd like to share with us advocates?
Oh, those are tough for all of us, I think, because we're talking about like multiple interpretation, right? And forms that aren't accessible and staff that doesn't know what to do. I think that depending on how the court handles those like applications for protective orders where they're just ex parte hearings, um, that I think is a good place to make those inroads, because if you can appear and say, this is what this person needs, to appear in the future, or call an office ahead of time and say, I'm bringing in a person who is this and this and this is what they need. I think that would make it much easier for the court to be able to accommodate survivors with those kind of multiple needs. And even if it's at the point of a hearing, if there's some way to prepare the court ahead of time, because, that's, I think, what we all hate. It's like, yes, I would love to provide access, but I don't have these people at the drop of a hat to come in and interpret and to figure out these forms. And the other thing that you might be able to do is get those forms ahead of time, and you probably have some of them, but some of the forms that they might have to fill out and that they might have to deal with, and see if they can be interpreted, by the people that you're using when you help these survivors. Because I think that so much of it is like, here's a bunch of papers, sign them, or here's orders, do this, or and they have no idea what any of us are talking about, and they don't understand, how this system works. And so many survivors, and especially immigrants, I think, are scared of the system because of where they came from and how the system works and how the law enforcement works. And so to me, that's a big thing, is to prepare those survivors going in, but also give the court time to be ready for them. We had a deaf-blind survivor who came in for a protective order with our advocate, and we had to figure out how to use, she had a machine that was very cool and it would send texts to the judge. And so I had her send texts directly to me while we filled out that protective order. And, that took a while to figure it out. And so that kind of thing, you let us know you're coming really for that kind of appointment or that kind of court hearing, and I think most courts will try to accommodate those kind of things.
Wonderful. Thank you so much for sharing that. That is a useful tip. I just thank you so much for your willingness to share your experience and to see your dedication, your efforts and support does make a huge difference in the lives of survivors and deaf folks who cause harm, who are involved in the court process. I just, you were leading as an example for other judges about how a judge can actually perform in a courtroom, but also outside of the courtroom, this level of commitment to access to procedural justice and, just a sense of the possibilities for survivors to achieve what they're looking for through a court process. doesn't often have a place. You know, you see me, you hear me, you understand what I'm going through, and you understand what I'm trying to achieve, is something that is rare and special. This process is, you understand that this process is hard for me. That level of empathy, I think, is really critical. And I just want to thank you for this conversation, and for overall being a leading example for other judges.
Well, thank you very much. I've really enjoyed the conversation.